Good evening, hello, and welcome to Dallas Parker's Provider Hour. My name is Ismail Laher. Some of you know me as Ish. I'm so glad that you're able to take the time out of your busy schedules to join us tonight as we continue with our topic, 10 Steps to Improve Compliance and Help You Stay Out of Trouble with the Government. We envisage Provider Hour as a resource designed to help you remain up to speed with regulatory issues that affect your practice, and we're trying to do it at a time that is convenient to you. I'm here joined by my colleague Andrew Dubbs sitting across the conference table with me. He'll be manning the controls. Last time Robert Lyles was helping me from Rochester. This time he's sitting across the desk from me. And Ashley Morgan is the other person with us on the phone today. Andrew, go ahead.
Well, thank you, Ish. So as Ish mentioned, today's speakers are Robert Lyles and Ashley Morgan. Robert Lyles is the managing partner of Lyles Parker. Robert's healthcare experience started back in 1984, first on the provider side, then after becoming a lawyer as a federal prosecutor in the Southern District of Texas. He has served as the first national healthcare fraud coordinator for all 94 U.S. attorneys' offices, and today he focuses his practice on healthcare, regulatory, and compliance issues. Ashley Morgan is an associate attorney at Lyles Parker's Washington, D.C. office, where she focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ashley is particularly knowledgeable about the regulatory challenges faced by home care providers, especially as they relate to issues of documentation, and has extensive experience working on administrative appeals of large alleged extrapolated overpayments assessed by CMS contractors. Ashley also assists providers across the country with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion and termination issues. I would like to now remind our audience that throughout the presentation, you are welcome to submit your questions and comments through the site, and if we have time, we will address them at the conclusion or during this webinar. And now, without further ado, I would like to hand it over to our speakers.
Thank you very much, Andrew. Ish?
Hey, Robert, how are you?
Doing fine, doing fine. Beautiful day in DC for one.
Oh, finally.
Just a gorgeous day. You got Ashley on the phone. Hey, Ashley.
Hi, Robert. How are you?
Fine. Tonight, we're going to pick up where we left off, and we're going to start out talking about exclusions. Now, exclusions, let me just give you the basics about exclusions. Essentially, exclusions they're what we refer to as the nuclear bomb of administrative sanctions.
Why is that, Robert?
Well, if you're excluded from participation in Medicare or Medicaid, not only can you not participate in Medicare, Medicaid, and other federal and state benefit programs, you can't work for anyone that takes those payer or that participates in those payer programs. So it really is very, very difficult for someone who has been excluded to really, continue in their line of work unless they're going to have a practice that is really cash and carry.
Once you're excluded, you're literally excluded.
You're excluded from participation in Medicare, Medicaid, FEHBP, railroad retirement, Medicare Advantage, Medicaid Advantage, all the different federal and state programs that are out there. And we're starting to see more and more private payers also say, if you're excluded from participation in Medicare, we don't want you to, or we're not going to really allow you to be a participating provider in our program either. Now, you may say, what is exclusion? Well,
exactly. I was about to ask you.
It's an administrative sanction that typically is imposed by the Office of Inspector General for one of three primary reasons. It comes in two types. There's mandatory exclusion, which is typically imposed because of a felony conviction, although it is possible for it to be under certain circumstances, it can be a misdemeanor conviction if it's a program-related crime. But typically, though, it's a felony conviction related to healthcare fraud or patient abuse. One of those two types of situations. Then you are mandatorily excluded from participation
almost automatic
for at least 5 years. Okay. Now, then there are also permissive exclusions, and permissive exclusions can result from misdemeanor convictions, from convictions related to non-healthcare convictions, non-healthcare related convictions, from licensure adverse actions. There are from licensure revocations, suspensions, surrenders, claims for excessive charges. I mean, there are a number of bases where a provider's status where they can be excluded from participation in federal state health programs. So the problem is, once you're excluded, as I indicated, you can't participate in these programs, nor can you work for an organization that does. And this is really what gives rise to probably what I believe, and I'm going to ask Ashley her opinion about this, but it's probably the single most significant compliance risk out there that most practices, most healthcare providers as a whole, aren't even aware of and aren't taking steps to avoid. Would you agree about that, Ashley?
I agree with that 100%. So many of the providers that I talk to, they check licenses, but they stop there and they don't know anything about exclusions, or if they do know about exclusions, they check people when they first hire them, and they're not checking them, every 30 days as they're supposed to under that 2013 guidance that was issued. And that's really problematic because a lot of the exclusions are based on exclusions taken by states, and that information doesn't get, always transferred from the states to the federal government in a timely fashion. And we see that sometimes somebody could have lost their license, in 2016, and they don't get put on the LEIE until, 2017. And then you have a year where you had that person that was providing services and you didn't know about it, and you have an obligation. Yes?
You said state and LEIE. I'm just to get our listeners up to speed. When you were referring to state databases and then you said LEIE, could you explain?
Yeah, absolutely. So the federal government, the OIG, has its own list of excluded individuals, and that's the one that most people know about if they know anything about exclusions, and that's called the LEIE, the list of excluded individuals and entities. Then there's also a list called the GSA SAM, which is a list of contractors that have been excluded from participation, but a lot of times the LEIEs will be captured in the GSA SAM as well, but you still need to be checking that one because the contractors are there too. But the states, there's about, I think, 38 states now that have their own individual exclusion lists. So you
another
need to
one just added to another one just added to the list. Now it's 39.
Really? Oh, wow.
Just last week. Yep.
Wow. So now there's 39, and the lists really vary from state to state. I mean, one state might have, a list of names, and another one might have, birth dates that you could check. And sometimes they're searchable, sometimes they're not searchable. It's really a handful, and you have an obligation to check all of those under the ACA in addition to the LEIE and the GSA SAM.
But now what happens, Ashley? Let's say that I'm a physician and I have a practice. Two questions. Number one, do I only have to screen my professionals that are licensed, or do I have to screen everybody?
No, you have to screen everybody. The guidance that was issued in 2013, goes as far to say that volunteers can't even be excluded from participation. So even if you're not paying somebody, if they're still there and they are participating in, the healthcare services that are being provided by your company, you have an obligation to screen them. Now we get a lot of questions from people, well, how far does this go? Do I need to, be screening, Xfinity or Comcast, like my internet service provider? There's a lot of questions there as to how far you have to go when you're talking about vendors. But as far as the people who are in your building, even if they're not paid, they need to be screened.
But you bring up vendors and contractors and agents, and that's important because those are required. But you're right. If it's a utility company or something along those lines, OIG doesn't require that you screen those folks. On the other hand, if it's a company that comes once a month and picks up your hazardous waste, that is a company that has to be screened.
It is.
So and the whole purpose of this, folks, is the government doesn't want 1 penny of monies that are being paid to that practice from Medicare, Medicaid, or other federal and state programs to end up either paying for the salary or overhead of an individual that's been excluded, or being used to pay vendors or agents. I mean, they're really saying, we think that these are bad folks. We don't want them associated with our program, and we don't want them taking care of our beneficiaries. And this is really important. And to Ashley's point, it's not just licensees that you have to screen. You have to screen your IT people, all your managers, and let's talk about what happens if you don't. Ashley, what happens if I don't screen and I bring somebody in, I hire somebody, and let's just say it's a medical assistant, you know, and they're in here 6 months, and then I find out, and they've been helping me take care of the patients the whole time, and then I find out that that individual who has been contributing to the basket of services has been excluded from participation the whole time.
Well, then you have been in receipt of overpayments from the federal government. So you now have an obligation to go through, once you've identified that, yes, that person was excluded, and you know when they were, what the date they were excluded or the date they were hired, you have to go back and you need to repay all of the money for the services that were rendered by that person, or that they were involved in directly or indirectly, because that if the government catches on to that later on and you don't do anything about it, then the penalties are much higher. You could be subject to treble damages, civil money penalties, and an assessment of up to 3 times the total amount that was billed by that person. So you really need to take proactive steps. If you do identify that, I would recommend to anyone that has that situation to contact legal counsel, because you may need to actually go through a self-disclosure protocol with the OIG to resolve that issue. But it's a big deal that needs to be handled very delicately, and we need to make sure we can identify exactly how much money was paid by the federal government during that period of time for the services that that person contributed to.
And that's an important point that you bring up. I mean, unfortunately, I've seen a number of folks that have utilized, they've tried to file a voluntary disclosure using the voluntary disclosure protocol for mere overpayments when they really should have just reported to the MAC to begin with. So, but I will tell you that when you find that you have improperly employed someone who's been excluded, the only way to cure that problem is to use the OIG's voluntary self-disclosure protocol. That's the only way to fix it. But Ashley, you mentioned early on, you said that the 2013 guidance OIG suggested once a month, but it's also true, isn't it, that some states like Texas actually have taken that 30-day requirement, and they have included that in their Medicaid participation agreement, haven't they?
That's exactly right. Yeah, we're seeing that more and more because, the states say, well, if the federal government's going to require this, then we want, our participants to do it as well. So everybody that participates in Medicaid needs to ensure that if they have that requirement, that they're checking those lists monthly. I mean, even if you're not participating, I think you should be checking monthly. But
that's right, and that's an excellent point, Ashley, because even if you don't take Medicare or Medicaid, think about this for a second. This is a risk issue. It's not a check the box issue. Even if you don't take Medicare or Medicaid, do you really want to have someone in your employment who has been convicted of a healthcare fraud crime or some other crime that resulted in their exclusion, or has been convicted of patient abuse or some drug crime? I mean, this is a risk management issue at its core. And while the rules are very strict when it comes to Medicare and Medicaid and other federal and state health benefit programs, even if you don't take those programs, even if you have a cash and carry practice, frankly, those aren't the kind of folks you probably want working for you, because they represent a risk to your patients. So you have to be really careful. And you also need to be careful because, we mentioned the Texas Medicaid participation application. New York has one very similar. when you sign up for Medicaid in Texas and in New York and in a number of other states, you're swearing that, number one, you have a compliance plan in place. Number two, you're screening your people every 30 days. That's what Texas requires, every 30 days against all 41 databases, not just Texas and the GSA and the SAM, all 41 databases. You know, and that's really important. And Ashley, you know, if you lie on that form, what happens?
Then you've made a false statement to the government, and you could be liable for a lot worse penalties than just failing to screen.
You know, we're here in D.C., Ashley. All these folks that have gotten in trouble, were any of them convicted so far for collusion?
No, they're, you know, convicted, you know, for lying to the government. You have to make
That's right.
you tell the truth, and if you have an obligation, you say you're going to do something, you need to make sure you're doing it.
So when you sign that form and you're swearing that you're doing all this is important stuff, folks. And if you think the government won't hold you accountable, just look up here in D.C. They will hold you accountable to statements that you make.
Absolutely.
And I guess, Ashley, the way you're explaining it, it sounds like it's not automatic that every state will update immediately whatever information they have that's negative. So if you don't check every month, you're just extending the period of negativity.
Exactly.
It's
That's
better for you to
exactly
check
right.
every month and minimize to 30 days whatever downside you have.
And the whole 30-day issue is really kind of interesting because, I mean, it's theoretically possible that you could check on the first of the month, and then on the 6th of the month, one of your employees hits the list because you didn't know it, but they were picked up on a drug crime, okay? Well, what OIG says is, as long as you're checking every 30 days, okay, you would pick it up then on the first of the next month. That individual is going to be on site now for 24 days while they were excluded. What OIG essentially says is that's still an overpayment, okay? They were there 24 days, okay, and you're going to have to pay back any overpayments that result from the fact that they were providing services when they didn't have the right to provide services to Medicare and Medicaid beneficiaries. But if you do have this system in place so that you're checking every 30 days, we are not going to assess civil monetary penalties, which is where the real damages are.
Because the other alternative was to check it every day, which is impracticable.
Even OIG doesn't expect you to do that.
Exactly.
That's right.
30 days is reasonable.
That's right. 30 days is what they're after. But, you know, that's a real sea change. I mean, this is nothing new at this point. But when it first came around, when it first came up, when they first said 30 days, that was a real sea change because prior to that, OIG wanted you to check it when you first hired somebody and then once a year.
Periodically.
That's right. But now they've made it very clear that's just not going to work. We expect you to check all of these databases. Now, all right, so then, you know, I mean, how do you do it? That's really how do you do it? And yeah, that's the slide we want right there. Well, you know, one way to do it, I mean, there are companies that you can use. We, of course, recommend exclusionscreening.com. They check all 41 databases for you, and it's very inexpensive. It's almost impossible, unfortunately, for you to check all 41 databases, even if you only have a staff of 5 people, because the 39 states that currently have these databases, one of them may have it in PDF, one of them may have it in Word, one may have it where it's searchable, one is not really searchable. It would take you a full FTE just to check 5 people.
It's an economies of scale argument.
You really can't do it.
A company that's figured out how to do it, it's far more economical to let them do it for you.
And, you know, to reiterate what I said earlier, it really is a risk management issue. Even if you weren't subjected to these civil monetary penalties, these are not folks that you really want in your organization.
Because the gentleman's got a criminal conviction and he's now working for you and you didn't know it for 6 months?
Yeah, and understand, at some point, even with a criminal conviction, they can go in, and after they've done their time in the exclusion, they can go in, as long as nothing else has happened, they can petition OIG to have that exclusion lifted. Once that exclusion is lifted, you know, then OIG says, okay, well, we think they're back on track, essentially. We're okay with that person now, as long as they've got their license still.
And licenses lapsing is another big one.
Well, license elapsing results in a permissive exclusion, or really it would be mandatory until they get it fixed, you know, but that's one of the biggest reasons. But, you know, this is a big deal, and one of the reasons why you have to check not just your employees and your agents and your vendors, but also your referral sources. There's a case that recently came out in New York where a doctor had been excluded. The doctor was excluded, but he still had his medical license, which can happen, okay? He could still see Medicare patients.
Cash, for example.
He couldn't bill for them, but he could still see them. He still had his prescription authority. He wrote prescriptions to Medicare patients and to Medicaid patients. These folks then took these prescriptions down to a pharmacy, turned them into the pharmacy then filled them and billed the programs. They filled prescriptions that were written by an excluded party. So they got hit with these huge.
The
pharmacy got hit with huge civil monetary penalties. Okay, and the lesson there is, you know, I mean, this all goes back to what did our mamas tell us when we were in high school? You know, you're judged by the company you keep. You have to check. If you're a specialist, you know, and you're getting referrals from family practice docs, you need to be checking and making sure that whatever referrals you're getting, that they're not from an excluded party. What would you add to that, Ashley?
No, I agree with you 100%. You know, it taints the entire service because they weren't, you know, permitted to get that. He's participating in that bundle of services that are then getting filled, but, you know, by the pharmacy, or if you're a specialist and you're getting that order from somebody else, it's tainting that whole bundle of services. So it's really important that you're checking those people and that you're checking your vendors as well, and that you anybody that you have a business associate agreement with, that you're checking with them in addition to your people that you know have licenses and are working for you as administrative staff.
Ashley, help me with this. What's a business associate agreement?
So a business associate agreement is essentially an agreement that you put in place with, say you have a medical biller. That's a business associate. So you want to have a business associate agreement in place with them before you exchange protected health information, to make sure that you're in agreement about what your obligations are and what the business associate's obligations are to protect that protected health information and what will happen in the event of a breach.
And that really kind of brings us into this next issue, doesn't it, for step 5, and that is conducting due diligence before you enter into a business relationship with somebody.
Yes, it does. You know, that's one of the first things that you always want to do when you're entering into a new relationship with any sort of vendor. For example, we are business associates for all of our clients. We have business associate agreements for all of our clients. And that's one of the first things that we do when we get engaged with a new client, is we make sure we get that business associate agreement in place so everything is covered under HIPAA. So when you are, you know, considering a new relationship with, whether it be a biller or if you're going to have an independent contractor work for you as like a physician work for you as an independent contractor, when you're getting those contracts signed, you need to get that business associate agreement in place at that point. And that's also a great time to do your screening, your exclusion screening. If you need to check any licenses, that's a great time to do that as well. You want to get all your ducks in a row before you get too far down the road with that person.
Exactly. Next slide. Okay. Co-payments and deductibles. This is, Ashley, this is something that I can't believe we're still talking about.
I know. It's really interesting because, you know, it's one of those things where it's really our provider's best way to make a profit because they're not getting paid anything from Medicare or from the private payers hardly. And this is the one way, you know, you can make sure you're making a profit. But so many of our clients, you know, aren't collecting their co-payments and deductibles because they're so worried about, you know, making sure they keep their patients happy. But you have to collect these because you actually have an obligation to collect them, and it could cause a lot more problems for you if you do fail to collect them.
Now, you said there's an obligation. What is the obligation if you're talking about Medicare and Medicaid? Well, Medicaid's not going to have one probably, or if there's any amount that they have to pay, it's really negligible.
Yeah.
But on the Medicare side, what is the obligation that you're talking about?
Well, I mean, it could be considered a kickback because, you know, you have you're agreeing with Medicare that the patient's going to have some sort of skin in the game when they are receiving these services from you. So, you know, they're going to pay 10 or 20% of the amount, and and the insurance company is going to pay you, you know, 80% or whatever the difference is. But if the patient's not actually paying you, then theoretically the payment should have been 80% of what the payment that you're receiving is, instead of the 80% of the total 100% payment with the co-payment. And that's incentivizing patients to come see you if they tell everybody, or if they know, well, if I go see this doctor, I'm not going to have to pay a co-payment, so I'm going to continue to go see him and give him more business.
And I will tell you, Ashley, we've talked about this just over the last 6 months. Even though this is something that is so old, I can't believe we're still talking about it, just like we're still talking about Incident 2. But there have been a handful of indictments that you and I have seen where they threw in the fact in the indictment as part of the criminal charges that the provider had improperly waived co-payments, and that was one of the examples of the kickbacks. So this is not something that the government will just blow off. I haven't seen a case brought solely on co-payments, I will tell you that, but I will tell you also that if they've got anything else out there, they'll throw it on the indictment along with it.
Absolutely. And I think as well, licensing boards may take action against providers as well, you know, if they know that this is going on and you're not taking proper action to make sure.
And we've actually seen those cases, haven't we? Because the private payers, believe it or not, are filing complaints with the state practice board, the licensure board, saying that it's a violation of their professional conduct because they're lying when they're submitting these 1500s, and they're not collecting this, even though it's a requirement under their contract. And these boards are, in fact, opening files based on these complaints.
That's absolutely right. So, you know, it's really, not only is it a good business practice to collect co-payments, but you actually need to do it. It's an actual requirement to make sure you're not getting into criminal trouble or into trouble with the licensing board.
And that's a point that you made when you first started talking about this. I mean, we do a lot of work with billing companies, and your whole point earlier, Ashley, was in today's environment, we have all these unfunded mandates. You know, it's not like the government is paying these doctors for half of these new things that they have to do. Mm-hmm. A good example is HIPAA. You have to, every year, you have to do a security risk analysis. Well, that is a very time-consuming and costly effort that they have to do. I know because we do it every year here at the law firm. You know, but that's just one thing. Maybe you may get some relief on the EHR side. The EHR, I can't tell you how many of our clients they're on their second or third EHR system because the first one wasn't worth a darn. So we've got that. We've got all this compliance training that has to be done. There are so many things out there now that the government insists upon, but your reimbursement, it's not going up, it's actually going down. And your point, Ashley, about, you know, the co-payments and deductibles, that's your profit. Mm-hmm. You may not realize it. You probably won't go out of business if you're not collecting it. You could get in a lot of trouble, but you may not go out of business. But you're not going to make any profit. That's where the profit lies in your practice, is collecting those co-payments and deductibles. It's just good business, and frankly, it's the law or it's a requirement under your contract to collect those monies.
Let me ask you folks, you know, you get patients that say, look, I can't afford the deductible. Do we have any room to accommodate them, Ashley, or?
Yeah, so I was just about to say that, Ish. So, you know, there are situations where, you know, we might not be able to get the payment from the patient, or they might actually not be able to afford it. And in those situations, there are things that we can do. For example, you can have a patient fill out a waiver. It's essentially a financial hardship application, and there's certain things that they do have to show to demonstrate that they do actually suffer from a financial hardship and are unable to pay. But once they fill out that information, you can keep it in your files, and then you can waive the copayment for them. But you need to make sure that you go through the proper steps to make sure that that waiver is complete. And alternatively, I do understand that sometimes you cannot collect a copayment from a patient, even though you are trying very hard to collect a copayment. So you need to make sure you do have some sort of policy in place about what steps you're going to take to try to collect these copayments. For example, for initially you're going to ask for it at the office, then you're going to do a letter, then maybe one more letter, and you need to keep track of all of those attempts to collect that copayment. And then, once you've made a good faith effort, which I would consider at least 3 attempts to collect that money, then you can consider writing that amount off. But you need to make sure you are documenting all of those attempts in your financial records.
What I'm hearing you say, Ashley, is you cannot do waivers for just about everybody. It's going to be on a patient-by-patient basis.
Exactly, yes. And there needs to be proper documentation of the actual financial hardship.
Ashley, before we keep going, we got to back up a little bit because we got some questions here on exclusions we need to address.
Oh, okay.
The first one is, can you work in the office as a receptionist but not do billing if you're excluded from the program? So, can they be a receptionist, and can we just kind of make it to where they don't have anything to do with billing? Would that work if they're excluded?
Unfortunately, I don't think so, because it's really, if you're accepting Medicaid or Medicare, it's really hard to separate out, here's the money we receive from Medicare or Medicaid, and here's the money we receive from private payers or cash and carry, and we're only going to pay you out of this one piece of money that we have. It's just a really difficult thing, I think, to do, and I just don't think that person, they're still participating in the bundle of services because they're the receptionist, they're in there greeting people, they're scheduling appointments, they're dealing with PHI, so I just don't think it's a good idea.
No, if
the bundle of services is the phrase that covers it well.
If they're excluded, they really shouldn't be coming in that front door. Okay, next question. How do we find out how to see the list for each state? Is there a way to Google search for each LEIE list? Well, no, there is no easy way to do it, which is kind of why we recommend somebody like exclusionscreening.com.
Yeah, they're very difficult to run.
Is it better to check every 2 weeks? Well, sure.
Minimizes the period you could be in trouble.
Yeah. Sure, it's better to check every 2 weeks, but, we're just, at this point, we're just encouraging folks to do it once a month because most folks, unfortunately, aren't. The next one, I work for a DME company, so every single one of our patients are directly referred to us by another doctor. So do we need to be checking every one of our referral sources? Well, if you're going to be turning around and billing for that DME supplies to Medicare or Medicaid, yes. Because you can't be billing for DME supplies that have been ordered by an excluded party.
And the example you gave of the prescription being made to the pharmacy is very similar to DME services. The doctor could be excluded, but still a script writing authority and could ask for DME supplies. It's the same thing as pharmacy, right?
Okay, then the last question is there any way for me to know if a provider has ever been on the exclusion list? That's a good question. Because, it's possible they could be on it and then now they're off the list. Ashley, I don't know if the LEIE, some of the state lists would actually list if a person was excluded, and then they would list the reinstatement date. Okay, so that would tell you, that at one point they were on the list. I'm not sure how the LEIE is set up in that respect.
Yeah, I think if you search the LEIE, they're not going to show up. You may be able to get the historical data from them because they do post, a list every month. They post like an Excel spreadsheet of everybody that's excluded. So you could probably go back in that historical data and find it, but you might be searching for a little while.
Okay, excuse me. All right, let's move forward. False Claims Act. Ashley, tell us about the False Claims Act.
So the False Claims Act is a federal statute that essentially says that anyone who knowingly submits a claim to the government for services or something along those lines, and knows that they actually didn't qualify for example, say I submitted a claim to the government for seeing a patient and I didn't actually provide that service, and I know that I didn't provide that service, but I'm going to get paid for it. That's a false claim. It means that you have done something, you've submitted something to the government for payment that you know didn't qualify, and that you've received reimbursement for it. And they actually have defined knowingly to not actually just mean actual knowledge, but to operate with reckless disregard and deliberate ignorance, which I can kind of consider as, we've been talking a lot about exclusions. Well, if I had somebody working for me and I knew I needed to be screening for exclusions and I just didn't do it because I didn't want to deal with it, that could be considered reckless disregard or deliberate ignorance, because you're just failing to screen for those people, and then you end up having somebody that's excluded.
Robert, I heard you once talk about the origins of the False Claims Act. It had something to do with Lincoln, right?
Well, it's a very old statute. It's referred to by some folks as Lincoln's Law. It was passed during the Civil War, and it was originally passed to deal with war profiteers. And these defense contractors in those days would send barrels up to the front lines, and they would be paid for them, and they would open them up, and they would expect to find munitions, and it might be full of rocks. So the government passed a statute to deal with folks who were committing fraud.
Filed a false claim
against the government. That's exactly right.
That's the origins, and now it's carried over into the healthcare arena as well.
And on the healthcare side, I will tell you that more than, I believe it was last year, it was $2.5 billion.
It was 8, if I remember.
It wasn't that much. It was 300,000 more than the previous year. You're right. Was collected under the False Claims Act in connection with healthcare cases. And this is a huge issue.
It's also known as whistleblower lawsuits.
Well, that's right. One of the provisions in the False Claims Act allows an individual who knows of the fraud to essentially step into the shoes of the government and file a case under the False Claims Act on behalf of the government. And it's filed under seal, which means that no one knows about the case's existence other than the federal government and the individual that filed it and his attorneys. And that gives the government an opportunity to investigate the allegations. If the government intervenes in the case, in other words, they say, yeah, we think this is a righteous case and we want to pursue it, and there's a recovery, then that whistleblower can get between 15 and 25% of the recovery. If the government decides not to intervene, in other words, they say, well, we don't really want to put our resources into pursuing this, but the whistleblower still goes ahead, then the whistleblower could get up to 30% of the recovery. I will tell you, most of the cases where the government does not intervene, most of those cases die on the vine. But it's also important to keep in mind that of that 2.5 or 2.8 billion dollars that was brought in, the vast majority of that money was brought in by cases that were initiated by whistleblowers.
That's absolutely right. And I always tell providers, this is why, not just because of this, you should listen to your employees regardless, but you really need to make sure you're listening. If you have somebody come forward and say, there is an issue here, I think that something's being billed wrong or something is not right, we need to look into it. You need to make sure that you're investigating all reports like that and ensuring that there's not actually an issue, because if you ignore that complaint, or if you, even worse, fire the person who brought that to your attention, then that person is incentivized to file a False Claims Act case against you, and it's going to be, a lot worse, because there's very large penalties for False Claims Act cases.
That's right. That's exactly right. And I will tell you, when I was a prosecutor, and on the defense side for that matter, I've never had a False Claims Act case where the whistleblower didn't go to management several times and say, this is wrong, we shouldn't be doing it this way.
Mm-hmm.
And management just blew them off. And in some cases retaliated against the whistleblower. Now, there are some other important changes to the False Claims Act that are worth bringing up. Can you tell us about the 60-day rule?
Yes, absolutely. This is one that we've seen, a lot of action with recently. There's been an obligation to return monies that are considered an overpayment. So, for example, if you become aware of a billing issue and you realize that you've been billing incident 2 improperly, or you have been billing a code improperly and you should have been billing for a lower code. You have become aware that you may be in receipt of overpayments, and you had an obligation to repay any overpayments to the government. However, until a provision of the Affordable Care Act was passed, there wasn't really a timeline on that, but now there is. It's within 60 days of when that overpayment is identified, you now have an obligation to return that overpayment to the federal government, or it can be considered a false claim. Now, they have clarified that a little bit more. You have about 6 months to actually determine the overpayment, and then 60 days to return it to the government at that point. So it's more like 8 months to actually figure out what the overpayment is and return it. But like I said, after that period has lapsed, it actually can be considered a false claim, and the government, if they find out about it, can say, well, we know that you found out about it because you probably have email correspondence or something like that regarding the issue back to this date, and you've had knowledge of this overpayment. You failed to return it, and now instead of just paying back what the actual overpayment is, we're going to assess the False Claims Act penalties against you, including treble damages.
Robert, remember you telling us a while back, if it ain't yours,
Give it back.
That's exactly right.
ain't yours, give it back.
That's a very basic rule that we learned in kindergarten. Okay, next slide. Now, we're not going to talk too much about Stark, just because, it's a snake
It's
pit.
a 3-day topic.
That's right. But essentially, Stark, which is the Ethics and Patient Referrals Act, known as Stark, it really stands for this idea that if a physician or his family member has a financial interest in a designated health service, then there are very strict rules as to whether or not you can be making referrals to those types of entities. And it really came up on the lab side, where physicians were part owners or owners of outside laboratories.
What's the ethical issue?
Well, the issue is they're trying to avoid overutilization. That's really what it comes down to.
Meaning because you own it, you'll send it off.
That's right. Because you own it, you're going to send everybody that comes in your office over for lab services or for diagnostic X-rays or outpatient.
And people may not need it, but they're getting it.
But Stark only covers a specific list of services, and those are referred to as designated health services.
DHS.
And DHS, and here's a list of designated health services. You want to add anything about Stark, Ashley?
No, I mean, you pretty much covered it. It's pretty specific, and there's very specific, safe harbors that you can do certain things underneath, but you have to make sure you comply with those specific safe harbors. So I would just recommend, if you are one of these designated health services, that you are in close contact with your attorney about any financial relationships that you have, especially if you have physicians involved.
Yeah. The term of art that they used for Stark is exceptions, and for anti-kickback statutes or the anti-kickback statute, it's safe harbors, but they're really the same thing. And I don't know why they really differentiate between the two. And for ECRA, believe it or not, I think that they're calling those exceptions, which makes no sense because ECRA really is a version of the anti-kickback statute. Okay, then we got the anti-kickback statute. And everybody knows what a kickback is, but essentially, if you provide any type of remuneration, which is a funny word for anything of value, if you provide anything of value in an effort to induce a referral, or a recommendation for a referral, or to solicit a referral, or anything along those lines, that is a violation. It's a referral of a federal health benefit service or program type referral, that is a violation of the federal anti-kickback statute. Okay, that is a criminal violation.
That's absolutely right. And it's important to note that you don't actually have to have specific knowledge or specific intent to violate the anti-kickback statute. So you don't have to know that you're going to be violating the anti-kickback statute when you're offering, these certain things. And I like to always point out that you can just offer to have some sort of kickback. It doesn't have to be accepted. It doesn't have to actually, nothing has to actually be exchanged. Just that initial offer or solicitation can be considered a violation.
And of course, we don't have a slide on it, but you do need to know that ECRA, which is the statute for Eliminating Kickbacks and Recovery Act of 2018, which was passed last October, that essentially took the federal anti-kickback statute and applied those same principles to the private payer insurance side. Okay, so now it's a federal crime for you to provide something of value, but only okay if you're talking about sober homes, substance abuse treatment facilities, and/or laboratories. So for the folks on the phone, unless you're working in substance abuse of some type, chances are your exposure here is laboratories. What are your business relationships with labs? Is the lab providing any type of remuneration, anything at all of value to you for referrals? That's really your exposure under ECRA on the private side. So ECRA, it didn't expand it across the board, only in these little designated areas, but the labs are the areas that most provider practices have to worry about.
I think the Texas definition of a kickback that's on that page is actually very well written.
Well, and ECRA, I think, in some respects was intended to kind of get past. Well, when I first saw ECRA, I was thinking, why are they even bothering with this? Because a lot of states, like Texas and Massachusetts, have all payer statutes already that make it a crime for someone to provide a kickback in turn for the referral of services, even if those services are paid for by a private payer. But most states haven't really been very active in utilizing these all-payer statutes. And, ECRA, I think, was intended, since it's dealing with the substance abuse side, it's intended to deal with the whole opioid issue.
So topical.
It really is. So that's kind of what we have to worry about. But you do need to keep in mind that there are, in fact, state statutes that cover a lot of these issues. So, some of the things, Ashley, what are some of the things that we kind of talk about in terms of, watching out for disguised kickbacks and bribes?
So there's a lot of different things that you can have. A big one that we see in a lot of cases, recently, a lot of the federal cases, is the medical directors. If you have a medical director for your health agency or your hospice, and you're paying them a certain amount of money every month or every 2 weeks, however you have the payments, you need to make sure that they actually are doing services that qualify for that payment, because that is a big thing that the government looks at to see, what is this medical director being paid to do, or are they just essentially paying this medical director, this physician, for referrals. Another one is lease agreements. If you have extra space at your facility and you're renting that out to somebody, what does that agreement look like? Is it a fair market value that person is paying for that space? And there is an actual safe harbor under the anti-kickback statute for lease arrangements, and you want to make sure you qualify under that. Something we get asked a lot. Well, what about sending somebody a gift basket at Christmas, or bringing them lunch and other things? Is that a kickback? Well, technically, yeah, that is a kickback. There is no de minimis amount for a kickback. So sending somebody a gift basket and bringing them lunch, that is still considered a kickback. And obviously, accepting cash or gifts for patient referrals, that is definitely a kickback. But even things like sporting events or tickets, tickets to a big basketball game or to a horse race or things like that, or liquor, we've seen all of those come up in our cases. So you need to, be really careful about the way you handle your relationship with your referral sources.
And I will tell you, liquor, that's one you touched on last. That's one that prosecutors, there's no excuse for liquor. The government doesn't like any of it. And I know this kind of goes against everything in your being, because when somebody does something nice for you, if they send you a lot of business, you want to say thank you, because that's what we do. We're human. But you have to remember that business courtesies and practices that are perfectly appropriate and legal in other industries are probably illegal in healthcare.
Mm-hmm.
So you just can't do that. The most what you ought to do is write a nice handwritten thank you card and send it to them. Okay. Now we're on the last issue for the evening. We're on HIPAA, and we've got, believe it or not, we have a number of HIPAA slides. So we're gonna go right into it. Let's talk about it. Encryption. Is encryption required? That's a really interesting question.
It is an interesting question. There are a lot of things in the HIPAA statutes that are addressable or required. And if you look at your actual requirements for encryption and decryption, it actually says addressable and not required. So what do you think about that, Robert?
Well, it's a weird thing. They say it's addressable, but they also say that if you don't encrypt and there's a breach, you're responsible, period.
Uh-huh.
So it's kind of a strict liability situation. So it's not the law necessarily that you have to encrypt, but it's very clear that if you don't encrypt and there's ever a breach,
You're on the hook for it.
You're on the hook.
Mm-hmm.
So we always say, always encrypt.
And nowadays, encrypting is not that expensive.
And it's not that hard. That's right. What about the mobile devices, Ashley?
Mobile devices, you can use mobile devices, but you need to make sure when you're doing that HIPAA risk assessment that you consider your risk with that with those mobile devices, and that you're taking appropriate steps to protect any PHI that might be on those mobile devices. So, for example, if you're going to have emails and things like that, or some sort of portal to access your patient records on that device, I would recommend having at least a 2-step login for that, in addition to working with your IT department to make sure it meets the requirements to protect that information. But yeah, you can use mobile devices. You just have to make sure that everything on there is protected.
And obviously, you cannot have a simple password. It goes without
No.
saying.
Well, yeah. All right. Now, this next case, this is this was a case out of Houston where they went after what I think is probably the world's best cancer center. And in this particular case, somebody had a laptop that was unencrypted, and it was stolen from the residence of an employee, and then they lost 2 unencrypted thumb drives. Now, collectively, they said that these 3 items had the PHI of 33,000 plus people on there. Now, remember, this is a not-for-profit cancer center, okay? What did OCR do? OCR hit them, and hit them hard, with penalties of $4.3 million. Now, I have to tell you, OCR says, well, we did it because they knew all the way back to 2011 that they were supposed to be they're supposed to be making all these changes, and they didn't make all the changes. Well, okay, maybe so. But I still think it's interesting that nowhere in the press release has anyone ever alleged that a single person's information has been compromised or used for identity theft or anything like that. More than likely, those 2 unencrypted thumb drives are in somebody's drawer, and the laptop, when it was stolen, the first thing the thief did was erase the drive. That's right.
Yeah.
So.
But your point is, it doesn't matter that the PHI gets used or not.
That's one point. The other point is, if they would go after a not-for-profit cancer center, they'll go after everybody on this call. So it's really, really important.
You read it.
Okay. We have a quick question here, Ashley. What about mobile devices being the sole way to answer and access queries.
To answer and access queries. So I'm thinking maybe we're talking about text messages, maybe.
Maybe so, yeah.
Yeah.
Which is, it's always problematic. I mean, text messages are. I mean, you have to understand there are programs out there that you can use that will encrypt your phone, and you can actually send encrypted emails and encrypted text messages.
But we still got to be very careful. If the chief executive of Amazon had his cell phone compromised, we got to be careful.
The bottom line is that phone is really one of your biggest risk issues, because your doctors, no matter how many times you tell them, they're going to be getting test results by text and by email, and they're not going to be deleting that stuff. They're not going to be erasing that stuff, and it's just a mess. Next slide. Okay, so one way, of course, to reduce your level of risk, and this is required, guys. This is not something that you have a choice. This is not optional. The first thing, and in every case that we've handled where there's been a breach, the first question that OCR always asks is, we want to see proof that you did your security risk analysis, which means we want to see that you analyzed your administrative safeguards, what were your technical safeguards, and your physical safeguards. And we want to see that you've done it year after year after year, not just now that you've had this breach. Okay? And I think this is important, and I really kind of liken this to the way I do with federal prosecutors. The government doesn't expect you to be perfect, but they do expect you to try. And therefore, I think if you actually have made a good faith effort to comply with all these requirements and to safeguard the information, there's really no way to perfectly safeguard all of this information. Someone could walk into an office, grab a folder, and run out, and there's not much you can do to stop that.
It's the same argument you made the last time on compliance plans. You got to try, you got to do the best you can. And if you're not perfect, the government takes into account.
That's right. That's right. Phishing email attacks. Ashley.
So, we've seen a lot of these phishing emails that people, you get an email, you think it's from somebody and it has, some sort of link in it, and you click on it, and then they get access to everything in your system. You just need to be really careful when you're checking your emails that, if it comes from somebody you think it comes from, you make sure it has the right email address. I know I've received them that look like they're coming from somebody that I know, and it's not. So you need to make sure you're very careful. It's happened to a lot of big entities out there. I know it's happened to some big hospitals, and they can hold your data hostage once they get access to your system. So you need to make sure you're training your people to double check those emails, and not just to click a link when they see it, to do a little bit of investigation before, we take any action with an email, because these people the hackers have gotten very sophisticated. Okay,
now, sextortion. Let's go a couple ahead, because I want to explain something first. Okay, right there. Sextortion. First of all, let me kind of lay the foundation. It's important to kind of keep in mind, there's a very interesting website out there called I Have Been, and I'm not sure what that says, pwned.com. Pwned, anyway. And they list these huge websites, that we all use, that, social media type websites and business websites and the rest of it, that have been compromised, breached, and in those things they've stolen literally hundreds of millions of emails along with the passwords. Well, for many of these types of things, whether it's an adult dating site, I think, or
Facebook. Today was Facebook.
Our business networking site, or a very popular file sharing cloud-based program. A lot of times people, they'll keep for when it comes to work, they'll have a pretty robust password, but a lot of times people have kind of a throwaway password that they use for everything from Facebook to LinkedIn. Okay. this is important to keep in mind. All these things have been breached. All this information is out there, and it's all being sold again and again and again on the dark web. Now let's go back to the first one. Okay, so what's happening is with the one above it, with that information then, what's happening around the country now is there are a number of these bad guys that are engaging in something called sextortion, you know, and they will send an email to you, and it will say, I've got your email and I've got your password, you know, and, you know, they will allege to have been videotaping you engaging in wrongdoing. Some of them will actually, some people will contact you, and you know, on some of these adult dating sites and these other social networking sites, and they'll get you to send them pictures, and then they will threaten you with a blackmail to give them money. Otherwise, they'll threaten to tell your work and your family and everyone else. And this is not something that is isolated. Apparently, this is going on a lot, and they're doing it because they have all these emails and all the personal information that they stole from these large networking sites. So, you know,
What can you do? What do you do then?
Well, the FBI says just ignore it.
Just ignore it.
They almost always want you to send them money in the form of Bitcoin, because apparently Bitcoin, and I'm going to have to defer to Andrew here, our young millennial, but apparently Bitcoin is very hard to trace. Is that correct?
Yeah, it's a decentralized currency, so in that regard, hard to trace.
Hard to trace. So
Doesn't keep its value, but that's another topic.
that's something else. The point, though, is if you get those types of emails, it's highly unlikely that any of it is true. Don't lose a lot of sleep. Don't send money through Bitcoin. It's up to you if you want to file a report with the FBI. I know that they actually have a page on their website for these types of reports because they try to keep up with how prevalent this is. But it is something that we're seeing a lot these days. So you kind of have to watch that. So what can you do then, Ashley, to just to kind of close us out for this evening? What can you do to reduce your level of risk for HIPAA?
So I would, first of all, just make sure you're doing that HIPAA risk assessment annually. Make sure you do it every year. You keep a record of it. Make sure you actually, if you identify risk areas, that you take action steps to protect those risk areas and to minimize your risk. Make sure you're backing up your data. Make sure, I would recommend that you do have an IT specialist that helps you make sure that you are meeting their requirements and that you have antivirus software on your computers. As Robert said, if a scammer contacts you for money, don't pay the ransom. Just, make a decision if you want to report it, but I wouldn't recommend, engaging with anybody. And if you're going to use mobile devices and laptops, make sure you have some sort of two-part authentication to be able to access PHI to have that extra protection there.
That's a good summary, Ashley. Thank you.
Robert and Ashley, I really want to thank you guys for another very informative hour. We finished the 10 steps. I think if you folks will remember, Andrew sent out a survey last time. He'll probably do that again. I think we've gone one step further and suggested if any of you want to block some time with Mr. Lyles or Mr. Morgan, the survey form will allow you to do that. Thank you again for a wonderful evening. Robert, closing comments?
No, I really appreciate y'all taking time out of your day. If you have any questions, always feel free to give us a call here at Lyles Parker. Thank you very much.
Andrew, thank you. Ashley, thank you. Good night, folks.
Thank you. Good night.